Good morning, everyone. Thanks again for joining us today. I'm pleased to have Paul O'Dwyer, immigration attorney extraordinaire in New York, with me once again, talking about his wish list as far as what he would change regulation-wise in the asylum space. Good morning, Paul. Welcome.
Good morning, Ali. Good morning, everybody. Nice to see you again.
Yes, so go for it. What would you change?
So there's a couple of things that I would change, and some of them kind of harken back to the pre-Trump era, to the Biden-Obama era. And this is what, of course, I think that Biden should do, assuming if he is elected, in addition to various types, and while waiting for various types of legislative fixes or legislative solutions to the immigration problem. The first thing I think he should do is they should enact proper DACA regulations after a notice and comment period so that they would be more immune from legal attack and to also broaden the people who are eligible for DACA also via proper notice and comment period. At the time that DACA was enacted, I did think that it was a broad use of presidential power and that it didn't set a good example for what future presidents might do. That turned out to be prescient, although we weren't thinking of Trump at the time. So that's the number one thing, is enact proper DACA regulations via notice and comment period. I think they also should enact DAPA regulations, which they had previously proposed but never enacted. And that would provide deferred actions to parents of US citizens who meet certain criteria, kind of, I guess, similar to, not necessarily the same criteria, but kind of similar types of criteria that you see for people with DACA. And then I would like to see a regulation that would, number one, authorize the issue of advance parole documents to people who have deferred action through DAPA or DACA, and a regulation also, or a DHS memo, one or the other, or both, saying that travel on advance parole to consular process, if you have DACA or DAPA, would not trigger the permanent bar or the 10-year bar or any other unlawful presence-based bars or departure-based bars. And that would have the effect of allowing large numbers of people to be eligible for family-based immigration and for employment-based immigration. And even if they were not lawfully admitted to the US and cannot adjust status here, that they would be able to consular process and take advantage of approved immigrant visa petitions without having to worry about the unlawful presence bar or the unlawful reentry bar, etc. And I also think that they should enact a regulation that would expand the 601A regulations to make it feasible to file an I-212 concurrently with an I-601A. At the moment, if you have a final order of removal, you cannot go to reopen your immigration court case and have it admin closed in order to file for 601A because, number one, the immigration court won't reopen it, and number two, the immigration court and DHS won't agree to administratively close it, so you're not eligible to file a 601A. As a result, people have to file an I-212, which puts about another 18 months or 2 years processing time on top of it. And once the I-212 is approved, then you file for an I-601A. So I think that we need a regulation that says you can concurrently file an I-212 and an I-601A, and also that they will be adjudicated within a 90-day period. So people don't end up waiting a year and a half or 2 years for either a 601A or an I-212 to be approved before they go on to like the next step in a multi-year process. I would also enact a regulation that would require the immigration court to reopen and admin close cases where people are prima facie eligible for an immigrant visa through consular processing, but for the lack of a 601A. Because I think it's unfair that we have a regulation, we have a 601A regulation, but then we have an immigration court court that steadfastly refuses to allow it to be implemented in the vast majority of cases in which it's needed. I would.
But that's 5 thus far.
That's 5 thus far. Yes.
Yes.
I know. So, and then when it comes to asylum, I mean, there's just so much to talk about, right? There's so many regulations. There have been so many proclamations. So the presidential proclamations can be undone with another presidential proclamation, right? So that's fine. But then there are a vast amount of asylum regulations that have been put in place, and more that are pending and that will be probably enacted between now and the end of the year, that essentially got most of the asylum protections available to people and make it practically impossible for people to claim asylum. So the president cannot simply undo prior regulations by saying, I'm issuing an executive order saying that all the previous regulations enacted by Trump are to be discarded, because the law doesn't work that way. However, I did a bit of research, and you can. So there's an act called the Congressional Review Act, whereby Congress can pass a resolution disapproving of a particular regulation, and then once the president signs it, then the regulation is no longer has effect, and the agency is prohibited from enacting another similar regulation. And so I think rather than going through the very, very lengthy notice and comment period to replace all of the Trump regulations with new ones, or even with regulations that rescind them, I think that we can achieve that end through the Congressional Review Act in the event that we have, a government in which everything is working together, and that becomes feasible. There are 2 other things I think should be addressed by regulation. Number 1 is the Asylum Office backlog, and number 2 is the Immigration Court backlog. And I think these are really significant because, one of the problems with the American immigration system has been an inherent tension, right? In that people apply for benefits, and then you're allowed to remain in the US while your application for the benefit is being adjudicated. And then it takes the government like 6 years to adjudicate your application. And then it doesn't take a genius to figure out that after a while, the delay becomes the benefit, and that there is a huge advantage to people who don't have good cases to apply for benefits that they're not eligible for, because it's going to take 6 years for it to be adjudicated and they get to stay here during that time. And then it also makes people who do have solid cases for relief very cynical about the possibility of getting them, and it injects fraud, it injects everything into the process. So we currently have a backlog of almost 400,000 unadjudicated asylum applications with USCIS alone. Then there is about 1 million cases in the backlog at the immigration court system. Those are not all asylum cases, but a large portion of them definitely are. And so we have the hundreds and hundreds of thousands of unadjudicated asylum cases. And I think that and before anybody else points that out, I'm going to point out that this is a result of years and years and years of poor management and inaction on the part of the asylum division within USCIS. And while there's some great people working there, there are also some clearly not very great people working there. And they have allowed a situation to develop where you have these cases that have been unadjudicated for years, and that based on their current plan, where they only adjudicate the most recently filed cases, and they can't even keep up with that. So you have cases that will possibly, based at the current rate, will not be adjudicated for another 10 or 15 years. And that's just like, you can't have an immigration system that works that way. You can't have any government system where people wait like 10, 15 years for a benefit application to be adjudicated. So I think we need a radical rethinking of the process of asylum adjudication in terms of timing. They need to get rid of the current process of adjudicating the most newly filed cases before the oldest cases. I think that they need quality control officers to come in to review all of the cases. I think that many of those, like 400,000 asylum cases in the USCIS backlog, are probably cases that will end up being referred to immigration court. And so if they're subject to one of the bars, I think people should be given the option of skipping the asylum office and going directly to the immigration court. As is typical of USCIS, they have refused to do this in the past if you ask for it, because they say they don't want to be perceived as allowing people to take advantage of the system, which is kind of like cutting off your nose to spite your face, because as a result, they've ended up with this massive backlog of cases that they can never adjudicate. Many of them filed by people who do want to take advantage of the system and who can. And then you also have people with very solid approvable applications that are going absolutely nowhere and that can never be done. So so one of the asylum offices in New York, if you don't ask them, they will ask you if you want to skip the asylum interview and have your case sent to court.
They do that in LA as well now.
Yeah, but if you contact the asylum office and you say, I have a pending case, I think it's going to be referred to court anyway for whatever the reason is, and state the reason. And I'm asking that we could skip the asylum interview and you just issue a notice to appear and send the case to court, they will say, no, we will not do that. So, like I say, I just think that's taking childishness to an art form at the expense of an entire adjudication system. So I really think that we need to work our way through the asylum backlog, send the cases that are going to be sent to court or likely to be sent to court.
But that's through regulation?
I think you can do a regulation or you can have DHS memo to that effect.
Right.
But I think that if you want something that is going to be a long-term, non-temporary solution, then you need to implement a regulation that does it. I think you can have a memo that says we're going to do this right away, and in the meantime, we're going to promulgate regulations to turn our memo into a regulation that has the force of law. You can do that. And I think that with the immigration court backlog, I also think that there has to be a similar approach where you have so many cases of that 1 million backlog. So many of those are people who are statutorily eligible for relief. There are adjustment cases in there. There are I-751 kind of related to family-based adjustment cases in there. There are people in there who just want to take voluntary departure. There are people who have solid, strong cancellation cases. And I really think we need like a team of hundreds and hundreds of people to start working their way through those cases, separating the approvable by stipulation cases from the heavily contested cases. And if it's approvable by stipulation, then we just, you get those cases, stipulated approvals or stipulated withdrawals where people no longer want to pursue various types of relief or whatever. But we work through that and get rid of all of those and then, have heavily conference the cases that are left so you can identify issues and you don't end up having to do immigration hearings where you have, lengthy trials and you spend all this time trying to establish really basic things. Like I was reviewing a transcript for an appeal I'm doing of an immigration court hearing on a cancellation case. And on the notice to appear, the person was charged and the judge found him removable to Guatemala. And the country of removal was designated as Guatemala based on his alienage or his nationality. And then the judge spent, like if you read the transcript, I don't know how much time it takes, but it's like 10 or 15 pages of transcript. And she goes on and on and on about the forms of identity documents she will accept in support of the cancellation application to prove that he's from Guatemala, even though she just found that he was from Guatemala.
I think.
Like these things should not even be coming to court. Like these should be like stipulated facts that are submitted to a judge. And then if there's a hardship issue and you have a mental health expert or a doctor who's going to testify about it or a parent who's going to testify about it, all of this really should just be done on paper.
For sure, immigration. So the regulation suggestions you mentioned earlier, those are just amazing because that would solve, I think, millions of people's problems. And it would just instantly declog the system quite a bit.
Yeah, because you have so many people who are here, who've had jobs for like 7, 8, 10 years. Their employers will sponsor them, no problem. Those I-140 petitions will be approved. And then what do they do? Under the current situation, they can do absolutely nothing. But if you have these DAPA regulations and 601A regulations, or the ability to travel on advance parole so you don't trigger a bar in the first place, then they travel the consular process, they come back with a green card, and it's done.
Yeah, it would instantly declog the system, generate much needed revenue for the federal government as far as, filing fees and whatnot, and
also have
increase
people
the
on tax
revenue, huh?
Yeah, tax revenue would be huge.
Tax revenue, I mean, just benefit after benefit. So totally agree with that. As far as the issue of the resolution, the congressional resolution, kind of assumes that you have the House and the Senate and the executive in the same party, right? So that's a big assumption. But
yeah,
as far as everything else, I think I agree with everything you say, but one huge problem is that somehow over the years, I think the break of the INS and then creation of DHS and then USCIS and ICE and so forth, somehow the idea of a government agency providing a benefit kind of got lost. And it seems like everybody is enforcing and penalizing.
Yeah.
And I think that just obviously doesn't work well. You have to have an agency. If you're going to have these string of agencies working in the same department, at least one agency needs to provide the benefit. Not everybody needs to be punitive, because then
I agree.
It's like if you go
to the DMV. It's like if you go to the DMV and then the person you go to see at the counter goes through all the reasons you cannot be given a driver's license.
Right?
It's exactly like that. That's exactly how it is. And I actually, preparing for today, I read the whole, Biden-Harris immigration platform. And I do have to say that there is, there's some things in there that are very appealing, and they sound just like, pointless talking points. But really, I think they would be very fundamental. They would lead to like a fundamental change in how immigration adjudications are approached from the top down and the bottom up, because they call for Office of Immigration Engagement, like public support for like community affairs officers, public outreach to immigrants. To have more of a we're working towards one goal together approach to immigration, rather than you're trying to get an immigration benefit and our job is to stand in the way of you getting it. And to, I've said this many times before, that, and they seem to be talking about doing something exactly like that, where you have a government that reaches out directly to immigrants saying, these are benefits, these are immigration benefits that may be available to you. This is how you can resolve your immigration status. You can come and talk to us, and you don't have to, about how to do this, and you don't have to worry that we're going to grab you up and deport you if you, come and approach us. And so I think there's like a fundamental reshifting in an approach to immigration adjudications, which I think is much needed.
Great. I mean, I'm glad to hear that. Great.
All right.
Thank you so much. Yeah. Thank you so
You're
much for your
welcome.
time, Paul. As always.
As always, it's been a pleasure. Bye.
You have a great day.
You too. Bye-bye.
Bye-bye.